let's revisit it, and if I were to sit on it again, and the case comes up again after, this period that is 1 year that has passed by, and I would add a few things to it. And these are some of my humble sort of suggestions. These are purely mine, of course. I would look at it on a fundamental rights framework. I think the fundamental rights were not really talked about. Maybe we all missed that out, but I think that needs to come in. I would look at right to life, and I would look at right to dignity more than anything else. I would anchor the whole judgment on the right to dignity, which is so dear to me as a concept, and I think that's the only one of the strongest fundamental rights which is not subject to law, by the way. It's not subject to any law. You can never take away dignity from anybody. You could take away life subject to law, but never dignity. Article 14, if you reread it again, you'll see that. So I would reconsider such a judgment in the light of the framework of the fundamental rights. I would not be too pushed if the prison rules are missing. I would not be pushed if CRPC isn't really talking about it. I have right to dignity, which I could turn the whole thing around on right to dignity, right to life, and right to fair trial. I think that is absolutely, there's so much power in these articles that all the laws flows from the Constitution anyway. So I would base it on this. So, and I want to talk about dignity a little, because that's very close to my heart also, and I think it's a very important area. So human dignity encapsulates the notion. We're coming up with a lot of jurisprudence on dignity, so stay tuned, as they say. Human dignity encapsulates the notion that every person has inherent equal worth. This simple but profound concept has three elements. First, every member of the human family has value. This is important. No one can be dismissed, ignored, mistreated, or abused as if their humanity means nothing. Second, each person's worth is equal to every other person. No one's life is more important than any other person's. Third, human dignity inheres in the human person and cannot be taken away. So if you have to clap, this is the time. And so I've already mentioned that you talk about the right to life, which is also very dear, and fair trial, talking about this process. I would also put a lot more burden on the prosecution. I would say that they have to establish the case, and if on the record it has come that the person suffers from mental illness, prosecution better clear that point, you see. So I might fail as an accused, but prosecution must establish that, no, sir, there is no iota that this person is absolutely normal. There's nothing wrong with him. I think prosecution needs to do that. And I think the courts now need to move after reading this, and I'm sure the courts will. I don't know if there's a term, but more pro-mental illness kind of inclination or propensity, have a more proactive approach towards mental illness. That's important. We should be now more talking about science. We brought science into the two-finger test judgment that has come out. We're bringing science into DNA being the gold star standard or whatever. So we want to bring in more science, and I think the courts need to bring in more science. But another thing that we need to introduce in, Mr. High Commissioner, this is actually quite an Australian concept also, the therapeutic jurisprudence. We need to move on to therapeutic jurisprudence. Now this is for the well-being of the offender. The court must be so sensitive by looking at the whole thing that I must have a therapeutic effect on this issue. You can't sort of bring it in a company law matter or a taxation matter, but do bring it on when they're talking about human rights. So I think we need to introduce therapeutic jurisprudence in Pakistan. And we need to think about the well-being of that human being who's before us, and let's not be lost in what the prosecution is saying or what the accused could prove, but we could take up an inquisitorial role in such matters. So it need not be adversarial, to my mind. We could consider a slightly more inquisitorial approach in looking at this aspect. And, if it is established that Imdad or Kaniz or Ghulam Abbas were mentally ill at the time when the commission of the offense took place, I would rather acquit them, you see. There's no offense that they've committed. They ought to have been acquitted. Why life? I mean, by convicting them, you're still punishing them, are you not? So that really bothered me throughout the case, but you have a 5-member bench, you have to go along the end, and you wanted to come up with a judgment, but that did bother me. If we can establish that at the very beginning he was suffering from mental illness, then you can't give him any punishment, no conviction at all. So I would rather acquit the person if there was such a situation. So I think in a case that might come in future, we might consider this aspect that acquittal would be the solution and they ought to be sent to a facility or whatever, but we need to look at it with a human face. Where do they go? You see, we just decide things, but where does the person go? He's a human being or she's a human being. So rehab, facilities, we need to have that kind of aspect to the judgment also. We can't just say, turned into from death to life and then what? Where does the person go? He's suffering from mental illness. Should he not be or she be sent to a mental facility? Or what are the steps regarding rehab? The Supreme Court could say, okay, give us a monthly report on what you're doing with this person. That is therapeutic jurisprudence. And I think Safia Bano sort of pushes us in that direction. We need to go in that direction. I finish with a quote. The strongest people are those who win battles we know nothing about. Thank you. Thank you very much.